International BV and others against Herculito Maritime Ltd and others.
Yes. Yes.
May it please my lords and my lady, I appear on behalf of the appellant cargo interests, together with my learned friend Mr. Mark Jones and my learned friends Mr. Guy Blackwood KC and Mr. Oliver Kaplan appear on behalf of the respondent owners and their insurers. The appeal concerns whether or not cargo interests are liable under the contracts of carriage contained in or evidenced by the 6 bills of lading to contribute in general average towards the costs and expenses arising out of an attack by pirates on the motor tanker Polar on the 30th of October 2010. If the cargo interests are not liable under the bill of lading contracts, then the appellants are not liable under the average bond or the average guarantee upon which the claim is based. The structure of my submissions will be as follows. I will devote a few minutes, and only a few minutes, to the facts. I will then devote a few minutes to the critical underlying agreements and contractual documents. As they are referred to and referenced in the statement of facts and issues, I was not proposing to spend time looking at anything other than the most pertinent aspects of the documents, but I'm entirely in your lordships and your ladyships' hands in that regard. I was then proposing at much greater length to address issues 1, 2 and 6 in that order, effectively subsuming issues 3, 4 and 5 into the analysis of issue 2. There were 2 overarching introductory observations which I was proposing to make, but in the interest of time I will make them at the end if I have time. They're not essential at this stage. So to the facts, if I may. The facts relevant to this appeal are set out in the partial award, which is at pages 168 to 179, at paragraphs 1 to 30. They're summarised in the agreed statement of facts and issues at pages 3 to 7. As the tribunal found, pages 88 to 92, the context in which the charter was concluded, to the knowledge of both parties, was that the intended voyage was to be via Suez, and thus via the high-risk area, an area well known for the risk of piratical attack and seizure for ransom. And my learned friend, Mr. Kaplan, has very kindly prepared a map just to show you pictorially where the high-risk area is. And if I may, I'll hand that up to the court. This shows the position as at the time of the seizure. The insurance policy, the relevant insurance policy, refers to the high-risk areas. These change from time to time, and at the time that the contract of insurance was taken out, there was a particular regime in place. That, in fact, changed during the year before the seizure on 6 separate occasions, but the high-risk area at the time of the seizure is that reflected in purple on the map that you have before you. The risks of piracy were of a distinct and different order from the navigational risks encountered by a vessel on the voyage. They were very specific and productive of a very specific type of loss, namely the payment of ransom, and the express stipulation in the Gulf of Aden clause, to which I'll bring you in due course, page 477, to kidnap and ransom, made that clear, as did the inclusion of piracy in clause 39 of the BP Voy 4 form, the standard form. That's page 508. The parties clearly gave specific focus to the risk of piratical seizure and ransom and how it was to be paid for, namely by the relevant insurers of that risk. The owner's insurance policies excluded passage through this high-risk area in the Gulf of Aden, which, as you will see, passed from coast to coast. Accordingly, if the owners wished to undertake the voyage on the usual, most direct route, avoiding deviating via the Cape, they had to agree with underwriters on any amended terms of cover and any additional premium required. This the owners did before entering the high-risk area. The owners also took out specific kidnap and ransom insurance for the transit through this area, pursuant to which the underwriters expressly waived rights of subrogation against other marine and marine war risks policies, including normal cargo policies. In other words, they agreed to be the first port of call for an indemnity. The former extension of cover was granted on the express undertaking, that is, the additional cover under the Hull policy, was the express undertaking, and I'll take you to the document in a moment, that the latter specific kidnap and ransom insurance had been purchased with no recourse to war underwriters. In other words, they were assuming that they were first port of call and only port of call for their proportion of the risk. This confirmed their understanding that the kidnap and ransom underwriters would be the first port of call for an indemnity. Under the charter party, the additional premiums were for charterer's account, and although there was a cap on the charterer's liability in the event the cap was not exceeded, it is our case that there is evident a very distinct allocation of risk of on-voyage piracy, more than the mere setting of terms for the owners to conduct the voyage via Suez rather than the Cape of Good Hope, if this was the course they choose. It is the establishment, we submit, of an effective fund for the payment of ransom in the form of insurance for which the insurers were to pay. This is our case with which the tribunal agreed and to which I will return. As we know, the peril which gave rise to the most significant concern and against which special additional insurance was taken out eventuated, and the motor tanker Polo was seized and only released on payment of ransom of 7.7 million by the owner's underwriters. To the documents. In order to understand the nature of the dispute, it is necessary to identify the critical underlying agreements and contractual documents. These are referred to and referenced in the statement of facts and issues, and as you will already have read the relevant documents, I propose only to remind you of the most salient parts of the documents, and all of the documents relevant to the appeal are in the core volume. The charter is the document to which I propose to turn first, and that is at page 469. Those working on paper copies, it's tabs 22, 24, and 25. The owners had chartered the vessel for the voyage in question, one sees under title, to Clear Lake Shipping Limited, the chartering arm of Gunvor, by a fixture recap which is dated, you'll see, the 20th of September 2010. It stated further down the page, charter party form was BP Voy 4, a standard form in the industry, and then following the main contractual terms on pages 469, 470 and on to 471, following those, it stipulated three-quarters of the way down the page on 471, otherwise BP Voy 4 and Clear Lake shipping additional clauses to be incorporated into this charter party as follows. And then
This is page 470, is it?
This is page 471.
471, sorry.
I'm so sorry.
Two-thirds of the way down?
Three-quarters of the way down, otherwise BP Voy 4 and Clear Lake.
Oh, yes, thank you.
And then over the next pages, there were amendments to those clauses. And back to page 470, we see it was for the carriage of a cargo. The cargo is identified of fuel oil, maximum 2 grades, and under geographical from 1 to 2 safe ports, Tallinn, St. Petersburg range, to 1 port, Fujairah, or in Clear Lake's option, 1 to 2 safe port, safe ship-to-ship locations in the Singapore area. And on the top of page 471, the freight rate was specified per metric ton, 1 load port and 1 disport if Singapore, and likewise if Fujairah, to which the fixture recap added under the heading freight rate financial, all above via Suez, with Suez costs to be for owner's account, all expenses at load port to be for charterer's account, if STS, that's ship-to-ship transfer, all expense of charterer's account and to be settled directly by them. Now, the direct geographical route for such a voyage was via Suez and the Gulf of Aden. The arbitrators found that it was difficult to see how Fujairah could be reached without entering the Gulf of Aden high-risk area, but the voyage to Singapore could geographically have been performed by the much longer route via the Cape of Good Hope. In fact, you'll see from the map that we've shown you that it would have been possible to go to Fujairah as well as to Singapore via the Cape without entering the high-risk area. Then on page 471, halfway down the page, under the rubric terms, the fixture recap further provided GA, that's General Average Arbitration London, English law, and then, as I say, it included BP Voy form, and the BP Voy form begins at page 482, and it's to that which I'm going to turn next. The charter terms appearing in and incorporated from the BP Voy form included the following. Page 497, clause 19.2, provided the cargo shall be pumped into the vessel at the expense and risk of charterers and pumped out of the vessel at the expense and risk of owners, in each case only so far as the vessel's manifold. This is a clause which may have some relevance in the context of the issue of manipulation. Then page 504, clause 30.2, which provides that the bill of lading issued under this charter shall be deemed to contain war risks, both to blame collision and new Jason clauses. So it anticipated that the bills would include those. That is, in fact, what happened in this case. Then clause 39, page 508, clause 39.1 defined the term owners, and it identified the war risks to which the provision applied, and in the third line one sees that those include acts of piracy. 39.2 applied if at any time before the vessel commences loading it appeared that there were war risks. That, of course, is not applicable on the facts of this case. 49.3 is on page 509, and this provided that owners shall not be required to continue to load for the voyage, or to sign bills of lading for any ports, or to proceed, or to continue on any voyage, skipping 2 lines, where it appears at any stage of the voyage that, 2 lines down, the vessel, her cargo, crew, or other persons on board may be or are likely to be exposed to war risks. If it should so appear, owners may, and the word telex was amended in the recap to read email, by email request charterers to nominate a safe port of discharge of the cargo or any part thereof, and it goes on to make provision in those circumstances. If charterers do not respond, then the owners can discharge at a port of their choosing. 39.4. If at any stage of the voyage after loading of the cargo it appears in the reasonable judgment of the master and or owners, the vessel, her cargo, crew, or other persons on board the vessel may be or are likely to be exposed to war risks on any part of the route, including any canal or waterway which is normally and customarily used in a voyage of the nature contracted for, and there is another longer route to the discharge port, owners may give notice to charterers that this route should be taken. And then there was an amendment to the next part. The next sentence was deleted in the fixture, and there was an amendment to the beginning of the second part of paragraph 39.4, and that is set out at the bottom of page 475 and the top of page 476. It says lines 1249 to 1251, delete in such case through that originally designated, and then insert, in this event the owner shall be entitled, if the total extra distance exceeds 100 nautical miles, to the extra expenses incurred, which to include extra time and bunkers consumed as a result of having to proceed via an alternative route, less savings made, to be for charterer's account. Time shall count as lay time, or if the vessel is on demurrage, for demurrage. And then...
Were these clauses varied at all by the more specific clauses, or that this was part of the regime, was it? So the vessel could have decided it was too dangerous to proceed?
Correct. My was entirely correct. At any point, the vessel may have got into the Red Sea and said, we're not going any further, despite this regime.
Right.
It had the right, the liberty, to say, I want to be told to go to a different port because it's too dangerous. And if the charterers didn't respond, it could go to Jeddah and it could discharge the cargo, claim the entire freight for the voyage, and that would be the end of the voyage.
Right.
39.5, page 509, gave the vessel again liberties to comply with the orders of others, including those given by a government or under 39.5.2 by war risk insurers themselves. So this was a liberty given to them. And then at 39.6, page 510, of particular importance in this field of the law, if compliance with clause 39.2 to 39.5, if in compliance anything is done or not done, such shall not be deemed to be a deviation, but shall be considered as due fulfilment by the party concerned of its obligation under this charter. So a very important provision in favour of the owners. If they relied upon clause 39, then any alternative route they followed, any alternative port to which they went for discharge would not involve a deviation of the voyage. And then over the page 511 is the general average clause, to which reference was made in clause 30. And then finally, page 512, the lien provision. Owners shall have a lien upon the cargo for all freight, dead freight, demurrage, and the cost of a recovery thereof. So that was a lien, a contractual lien under the charter party.
So how do you say these liberties work with the Gulf of Aden clause?
The liberties remain in place to be used by the owner if the owner chose to do so. The owner retained a liberty throughout, and the exceptions would apply. But if it chose not to exercise its liberties and to go through the Gulf of Aden despite any concerns it may have, then the kidnap and ransom insurance taken out specifically for that purpose and the additional walrus insurance taken out specifically for that purpose would be put in place at charterer's expense. Just by way of, just for noting, in the context really of the issue of manipulation, there are references in the BP Voy form to cargo interests in 9 clauses. Page 494, clause 14.2, there's reference to cargo suppliers. 501, clause 23.1, there's reference to the charterers obtaining consent of the owners of any cargo at any time before requiring the vessel to be diverted. 30.1.2, page 504, charterers hereby indemnify owners against claims brought by holders of bills of lading against owners by reason of any deviation required by charterers under clauses 22, 23, 28. At 30.3, page 504, presentation by the consignee nominated by charterers the receiver, plus reference to the receiver in 30.3.1. Page 506, paragraph 30.1.4.
Yes, okay. I wonder if we could pause. Lord Hamlin's computer isn't working. I do apologise.
No, not at all. I'm so sorry that I didn't pick that up. I do apologise.
No, I don't see how you could have picked it up, in fairness. But I think we should adjourn briefly so that we can get this matter sorted, because he will not have access to the documents. So we'll adjourn, I hope, for a very short period.
Thank you so
Thank you very much. I'm sorry for the interruption. If you need, we will find time to make up for the time that's been lost.
That's very kind of Your Lordship, indeed. I was just picking up references to cargo interests in the BP Voy form, and I think the last few, I'll just give the reference. There's a reference in, this is 506, page 506, 31.4 to the bill of lading furnished by the shippers in 507, 33.4, liability to bill of lading holder, 40.1510, owners of the goods, 511, clause 42, cargo shippers, consignees or owners. That's in the new Jason clause where you would expect to find it, as with the previous in the both to blame clause. And then 511, clause 43, shipper or consignee, in the clause paramount, again where you would expect to find it.
If these references are important to your submission, perhaps you could just give us a written list at some stage.
Certainly.
Thank you.
Thank you, sir.
These are going to make manipulation a bit harder when you get to that, aren't they?
They are aspects that we have to deal with, exactly.
Yes.
There is, but the point that I was seeking to make about this, there is no reference to the shipper, consignee, cargo owner or bill of lading holder undertaking to do anything in any of these provisions. Two of the provisions involve active participation or input on the part of the bill of lading or cargo interests. Those are clause 14.2 at 494, which requires the master, in conjunction with cargo suppliers, to arrange for slots to be measured. And at 501, clause 23.1 provides charterers shall obtain the consent of the owners of any cargo on board at the time before requiring the vessel to be diverted. But the rest of the references merely mention the cargo party as part of setting the scene for the right or obligation of the charterer or owner. The references to cargo parties in the standard form back to both to blame New Jason and clause paramount provisions are unsurprising, as those clauses are worded for use specifically in the bills of lading and are found in the bills of lading. Back then to the recap, page 476. One sees at 2/3 of the way down the page the heading additional clauses. There is then an ICE clause and a Turkish Straits clause, and then on page 477 the additional clauses pertinent for present purposes, the Gulf of Aden clause for this charter party only dated the 20th of September 2010. In case the vessel for safety reasons is escorted by naval vessels and or restricted by daylight, and or if a protection team and or any other protective measures is employed, all time used while waiting escort and or waiting daylight and or waiting the protection team and or waiting implementation of protective measures to count as half time against used lay time or demurrage if vessel already on demurrage. Furthermore, if it is necessary for the vessel to follow fixed route waypoints and or to enter a convoy and or to deviate to pick up drop off a protection team and or implement any other protective reasonable measure and or to deviate from the usual route, additional costs, time and bunkers used to be shared 50-50 between owners and charterers. Any additional insurance premia, including but not limited to those in respect of hull and machinery, crew, P&I, kidnap risks and ransoms, crew bonuses, which to be in accordance with the international standard shall be for charterer's account, maximum $40,000 for charterer's account for any additional insurance premium, except for crew bonus, which is to be maximum $20,000 for charterer's account. And then the war risk clause.
Is that the actual crew bonus maximum, or is that insurance for the crew bonus?
That is for actual crew bonus.
Okay.
Yes, there's a distinction that's drawn between premia and then after the brackets crew bonuses, which is therefore the actual. The war risk clause, any additional premiums payable by owner in respect of war risks under their policies of insurance that are incurred by reason of the vessel trading to excluded areas not covered by owner's basic war risk insurance shall be for charterer's account. Any bonuses or additional premiums payable by owners in respect of their crew, which are due by reason of trading to such excluded areas, shall also be for charterer's account, picking up the point that my Lady Rose made a moment ago. The rest of the war risks clause is there to be read. It's not relevant for present purposes. But in our submission, these two clauses, the Gulf of Aden clause, the war risks clause, together with clause 39 of the BP Voy 9 form, stipulate the war risks regime in this charter party. And then page 478 over the page, one sees reference to the Clear Lake Voyage Charter terms. These begin at page 514.
So 478, you're looking at what, please?
I'm looking at the second paragraph heading Clear Lake Voyage Charter terms.
Oh, yes, thank you.
Those are incorporated as well, subject to the amendments made immediately below that heading. And for present purposes, the first relevant point to note is the deletion of AC4, additional war risk, delete, refer to owners' additional clauses. So they've turned their mind to it. They've specifically deleted a provision in the Clear Lake Voyage Charter terms, and they've referred the reader back to the additional two clauses which I've just referred the court to. The second point, if one goes to just looks at that provision, that's at page 523. AC4, BP War Risks Additional Expenditure Clause. There's a typed section in capitals at the end of that clause, and it's that which has been specifically deleted by the parties, and so therefore is not incorporated. The second point to note is
sorry, the bit in capitals at the end is actually not crossed through.
That is correct. It's not crossed through in the Clear Lake Voyage chartering terms, but by reason of the deletion at 478 of clause AC4, the Clear Lake terms,
yes, I understand,
had AC4 with the existing section deleted and had a separate part added. When the Clear Lake terms were incorporated into the charter party, they wanted even that deleted and for reference to be made to the owner's additional clauses.
So just putting it all together, how do you say it works in relation to kidnap and ransom risks in the Gulf of Aden charter party scheme?
The charter party scheme, which is the point that I've come to develop, the charter party scheme is that just as in the Evia, number two, the parties agreed an insurance code.
But before we get to that, in terms of rights, liberties to refuse to go there,
yes.
I mean, when do owners, they agree to go to Gulf of Aden, they can't thereafter say no for kidnap and ransom risk, can they?
Yes, they can. At any point before entering the Gulf of Aden area, clause 39 applies, and indeed continues to apply even in the Gulf of Aden area, and permits them to rely upon 39. But
if they choose to go into the area, then they get the benefit of the insurance being paid for by the charterers and have that protection. So it's a kind of encouragement to them, but it does not compel them ever to. It doesn't remove their rights to say, well, this is too risky at any stage.
If for whatever reason, if the circumstances changed, or indeed if they didn't change, the master formed the view, having entered the area that it was too dangerous to continue, he could turn around and go back and say, I'm exercising rights under clause 39, and therefore, and if he chose, of course, if he chose to do that before entering the Gulf of Aden, then any additional premium which had been paid would be returned, of course, because they were not required and not used, and that's always the case under the insurance.
If he does enter and there's no change in perceived risk, can he still refuse to go further?
The clause 39 operates, and he may still, if for example, Korean warships who are escorting ships through the area start a battle with Omani warships and a war breaks out in the area, then he's
well, that's a
entitled...
different risk, but if you're looking at kidnap and ransom risk, which is specifically being covered by the Gulf of Aden clause,
Well,
and you agree to go to the Gulf of Aden, and there's no change in that risk, you can still say, I'm not going any further, or I'm going to discharge somewhere shorter.
Well, it depends what one means by change in the risk. If, for example, there was local information to suggest that there were 100 pirate ships out unusually, the master at that stage could, on the basis of that new information, say it's too dangerous.
Right, so that would be a change of circumstances. So you're saying if there's no change of circumstances from the perceived risk at the time you agree to go there, you couldn't thereafter turn around and say, well, I'm not going any further.
No, I say that he could, clause 39 right, he still had the liberty to do that, but if he chose to go through the Gulf of Aden, then the additional insurance in respect of the Gulf of Aden would be paid for by the charterer and inured to his benefit. He didn't give up any of his rights as a consequence. It's not a case like the Helen Miller where one was paying the premium to buy the voyage, as it were. This is a case where he retains the liberties throughout. Moving then, if I may, to the bills of lading, which are obviously the matter which this court is required to construe. The bills of lading begin at page 536, tab 25, in tab 26 in the bundle. There are 6 bills of lading, numbered 1 to 5 and 084, Roman 6. They were issued by the vessel's master, dated variously the 29th, 30th of September and the 2nd October 2011. One sees at 536 that the amounts, a different amount under each of the 6 bills of lading, a total of just under 70,000 metric tons of fuel oil. One sees at 536, top right-hand corner, they are on the in-tank bill 78 form. Bills of lading 1 to 5 have on their reverse, page 541, which is the reverse of the standard form, but for some reason, Bill 084 Roman 6 at 542 had at 543 on its reverse what is in fact the congen bill form. So quite why that happened, we don't know, but nothing turns on it. The bills of lading back to 536.
Which page?
536.
Thank you.
Top right-hand corner contain words of incorporation, pursuant and subject to all terms and conditions, liberties, exceptions, as per tanker voyage charter party indicated hereunder, including provisions over leave, and towards the bottom left-hand corner, the text, the box marked charter party was left blank, and no charter party was expressly identified anywhere in the bills of lading, but it was, however, not in dispute that the only possible charter was the charter to which I've referred the court that was incorporated. In the box headed freight and charges, the words freight payable as per charter party, clean on board, were inserted.
What does freight payable as per charter party mean in this context? Is it referring to the freight payable by the charterer?
It's referring to the freight payable by the bill of lading holder.
Right.
And the bill of lading holder is obliged to pay freight in accordance with the charter party.
But how do they know what that freight is?
They know that because the charter party terms are incorporated, and they will have asked to see the charter party in order to work out what that is.
So the freight is payable by them to the owner, is it?
Correct. And then in the...
But if the bill of lading is negotiated during the course of the voyage, how then does the bill of lading holder know what the freight is? Does a copy of the charter party travel along with the bill of lading, or how do they know?
It may or may not. It depends entirely on the person who purchases the bills of lading as to whether they are interested in seeing the terms on which they're contracting, or whether they're not interested in seeing the terms on which they're contracting.
And that will depend presumably on what contract they have with the previous bill of lading holder.
It will depend upon the contract of generally the contract of purchase and sale of the goods, yes. Because the bills of lading will be negotiated in accordance with the contract of sale, and the contract of sale will be a contract between the shippers and the consignees, or any purchaser of the bills of lading. And then finally, on page 5.
It's very odd if it's that there's no... Why is it that the charter party is not identified then? They don't. The bill of lading holder doesn't mind that they're signing up on the face of the bill of lading. They're signing up for something which doesn't actually exist.
Well, it does exist, and if they want to know what it is, they must ask for it. But it is more often than not in the bills of lading, one doesn't find a charter party identified, a particular charter party identified, and there is a whole area of learning in the law as to which, because there may be a string of charter parties, as to which the relevant charter party is. But the point is that the person who purchases the goods and purchases effectively the bill of lading contract, that's a matter for it's their outlook. They need to look out for what that charter party provides, because those are the terms which are incorporated into their bill. And it's a point we make. These are short form bills. They're intended to operate together with the charter party terms. That's critically important. They're intended to rely upon, to be filled out by the charter party forms. If it were otherwise, you would see on the bill of lading pages and pages and pages of clauses. But that's not the way in which it's done using a short form bill. Instead, they incorporate the terms of a charter party. And then just alongside that box, there's a box beginning with shipped on board, and the final of those paragraphs reads, by taking delivery of the cargo, the consignee shall make himself liable for unpaid freight, dead freight, demurrage, and other charges.
So that's a typo, is it? It should be by taking delivery of the cargo.
Correct. Nobody suggested, and I think the standard form reads by taking. The significance of the clause will be explored later, but for present purposes it's sufficient to note that the standard form anticipates the consignee, by taking delivery of the cargo, making itself liable for four matters, including demurrage, none of which are provided for in the Bill of Lading, only in the Charter Party. The Bill of Lading 08 Roman 6, page 542, on its face includes the same incorporating provision, top right-hand corner. On its reverse, the Congen Bill, page 543, it has an additional incorporation provision. All terms, conditions, liberties and exceptions of the Charter Party dated as overleaf, including the law and arbitration clause, are herewith incorporated. So this goes further than the Bill of Ladings 1 to 5, and incorporates also the law and arbitration clause of the Charter Party.
So this in-tank bill is meant to operate with tanker voyage charter parties, not a specific version of tanker voyage charter parties. Is that right?
I stand open to correction, but I believe there is an in-tank bill,
Right.
an in-tank charter,
Right.
but it is used, again, I stand open to correction, but my own experience is it is used with numerous different forms of tanker voyage charters. It is unusual in my experience to have an in-tank bill on the front of the bill and a Congen bill on the reverse. Each of the bills contain express paramount and general average clauses in usual form. Bills of Lading 1 to 5 provided for the application of the York Antwerp Rules 1974. Those are the rules applying to general average, whereas Bill of Lading 084 Roman 6 provided for the application of the York Antwerp Rules 1994 rather than 74. So there was again a disparity, but the distinction has not been relied upon as being material in this case. In addition, page 541, Bills of Lading 1 to 5, but not Bill of Lading 084 Roman 6, had a vertical marginal note on the right-hand side. One can see it at right angles. For the purposes of the Bill of Lading, shipper means the person consigning the cargo for the carriage on charterer's behalf. Charterer means the person entering the charter party contract with the carrier. Carrier is equivalent to terms like ship owner, owner, chartered owner, disponent owner, whichever is used in the charter party in this Bill of Lading to define a person undertaking the carriage. So the marginal note was part of the printed in-tank Bill 78 form. Moving on, the GA bond is page 584. I wasn't going to take you to its terms. The GA guarantee is at page 587. I was going to go next, if I may, to the insurances and begin at page 544. Before I say that, the cargo underwriters wrote the insurance of the cargo on familiar terms. The other insurances, I say, have some relevance, and I turn to those. We don't have the cargo insurance terms in the papers. They never have been. Page 544 is the confirmation of the owner's insurance, and at 545, alongside the rubric interest, one sees that it had 3 sections of annual cover. Section 1, hull and machinery. Section 2, disbursements and or increased value. Section 3, war risks on hull and machinery and protection and indemnity. And it's the third of those which is of particular relevance in this context. On page 546, one sees the trading limits and the second sentence in respect of war risks, JWC Hull war risks, war strikes, terrorism and related perils, listed areas, 11th of June 2009. That was the listed area circular given by the Joint War Risks Committee on the 11th of June 2009. In fact, during the year that changed on 6 separate occasions, and it's the list in August 2010, which is relevant for present purposes and which is depicted on the map which we have shown you. The annual cover, page 547, this insurance was governed by the law of Florida, but nothing turns on that. Going back to 545, Section 3 of the insurance covered war risks. 546, the particular terms were conditions Section 3, halfway down the page, institute war and strikes clauses, hulls, time, 1st of October 1983, clause 218, as amended by JW 2005-002, 17th of October 2005. The hull and machinery insurance was written on the 12th of July 2010, page 554. We come to the endorsement to the war risks insurance, which was taken out specifically in order to enable the vessel to enter the high-risk area. Under its policy of insurance, it was excluded from this area. It had to purchase, by paying additional premium, specific cover to be able to go through the Gulf of Aden. And this it did on an endorsement dated, you see towards the bottom of the page, the 22nd of October 2010. The period, one sees arrival date, 26th of October, Gulf of Aden, estimated departure date, 30th of October 2010, Gulf of Aden, into the Indian Ocean. An additional premium was charged for the voyage, including coverage through the Gulf of Aden for a period not exceeding 14 days. And at the bottom of the page in manuscript, the underwriter, when he subscribed to the endorsement, scratched specifically $5 million KNR, that's kidnap and ransom cover, purchased with no recourse to war underwriters hereon. So they were making it absolutely clear that they were only going to be on risk once the 5 million kidnap and ransom had been paid and exhausted. That was a reference to the kidnap and ransom insurance, which you find at page 571 and following. This was taken out with Griffin, top right-hand corner. It was broadly as contemplated.
Sorry, which page are we at?
Page,
I'm sorry, page 571.
This is the kidnap and ransom.
This is the
That's
kidnap.
the first 5 million, basically.
Correct. It was broadly as contemplated by the terms of the charter party for a single voyage not exceeding 14 days, one sees that period of insurance, which was then thought to cover the vessel's transit of the high-risk area. And the geographical limits are stated to be one voyage from Suez to Singapore, including one Gulf of Aden transit. Again, this was purchased as the vessel approached a high-risk area, so some time after the bills of lading had been signed and the cargo loaded. The kidnap and ransom insurance, page 575, provided an indemnity, one sees it in the insuring clause, in respect of insured losses as defined, sustained directly because of insured events as defined, occurring during the period of the insurance. And the definition of insured losses is below that, and it included one, ransom which has been surrendered under duress. In the case of marketable goods or services, the underwriters will pay the actual cash value of the goods or services at the time of surrender. And it includes 3 fees and expenses incurred by the assured and by the underwriter's advisors. Page 574, the kidnap and ransom insurance also contained a statement by the underwriters 2/3 of the way down the page before the section that is capitalized. We waive all rights of subrogation against other marine and or marine war risks policies. So again, they had clearly in mind what cover they were providing. They were providing the first 5 million of cover in respect of kidnap and ransom risks.
What does that actually mean? Is that limited to other marine war risk policies taken out by this assured?
Yes. I would assume so.
Or is it broader than that? I mean, this is a clause that the tribunal mentioned a couple of times in their partial award, but doesn't seem to have featured a great deal subsequently. And I, for one, was wondering what it actually means.
Well, there are two. One can read it in 2 ways. One can read it as against other marine and marine war risks policies taken out by the assured, or one can read it as it stands against other marine and or marine war risks policies. And in our submission, that is the appropriate way to read it.
But you can only make a claim against another policy if the same insured has double insurance, or more than one policy potentially on which to claim. And then you could seek a contribution from another insurer, which you're waiving the right to do here.
Yes, you're waiving the right of subrogation, but the right of subrogation that you may obtain from the owner may be a right which is exercisable against cargo interests who have marine or marine war risks policies.
Well, that's true, but that's not a right against the policy, is it? It's a right against the cargo interests. If they happen to be insured, that's their business, but this doesn't apply in that situation.
No, that is correct. That is absolutely correct.
So it's what is correct? So it doesn't. I see. So the fact that the cargo interest here is insured doesn't mean that the subrogated right that the ship owner's insurer is exercising is a right against that policy, that it's a right against the cargo interest, who then may or may not claim on their own policy. Is that the distinction that's being drawn?
No, because the claim if the claim, the owner would have its own additional insurance, and the underwriter on this is effectively saying, I'm not going to make any claim which will impact upon owner's additional insurance. And we are saying that additionally they're saying we will not make a claim which has an impact on any marine or marine risk policies.
Are you saying or not that the claim in this case was a claim against the claim against cargo interests in this case was a claim against another marine policy? It wasn't, was it?
Because we're saying that the scheme that was agreed between the parties was an insurance code, and therefore there never was a claim in general average, and therefore there never was a claim to make against the cargo interests and all risks insurers. We refer to this merely to indicate that it was, at this time in the market, people writing this specific type of risk were doing so on the basis that they were going to be the first and only port of call for the 5 million.
I would have thought this is simply making it clear that if the ship owners have another war risk policy or some other insurance, which they also prima facie could claim on, that these insurers won't be able to seek a contribution from those other insurers.
Well, we can certainly include those, but it would be most unusual for the owners to have a separate and different insurance policy of that kind. But there it is. I mean, I've made the...
So you're not relying on it contractually?
No, because we're saying... in this area of the law, where insurance fund, it is the arrangement between the contracting parties to the underlying commercial contract, which is critical, the bill of lading contract. The insurance position is not relevant to that.
Is there anything in these insurance documents that indicates that the insurers were aware that under the charter party the premium needed to be paid by the charterer rather than by the assured?
I stand open to correction, but in my reading the papers, there's no indication that the owners' underwriters, either additional, either the war risks insurance or the kidnap and ransom, knew that the charterers were going to be billed for it. As far as they were concerned, it was a matter of supreme indifference. They were being paid by the owners, and whoever the owners might...
Well, it becomes of interest to them if the effect of the charterers paying the premium is that they have then no recourse to the general average. Then it does become interesting to them.
That is absolutely right. The insurance code cases, however, that's not a factor that's pertinent in the context of considering whether or not there's an insurance code. The underwriters take the consequences of the commercial agreement between the commercial parties.
But wouldn't the insurance premium be different, higher, if they realised that they did not have any recourse to the charterer or the bills of lading holders for paying out this ransom than if they were insuring on the basis that they would have that recourse?
That may or may not be the case, but that is true of all joint insurance cases, all insured cases.
Co-assured is a different thing, because then presumably the insurer does know that there are two assureds.
They know that there are two assureds, but they don't know who's paid the premium.
No.
And in the Evia, there's no indication at all that it was relevant to the inquiry whether the insurers knew who was responsible for the premium.
Even though you accept that it makes a big difference to them, if you're right that there's this code created by the payment by the charterers, and it makes a difference to what premium they're likely to have charged.
Yes, it does. I accept that it may make a difference to them. In the context of the kidnap and ransom, they were taking on a very specific risk to the vessel, and they were agreeing that they were going to take the first 5 million, come what may. If the insurance code doesn't operate, they are in fact getting away with paying much, much less than 5 million for the kidnap and ransom which they insured. If I may then move on to the issues, which I'm now going to take at greater length. Issue 1, implicit understanding in the charter party. The first issue which arises concerns the construction of the charter. Was there an implicit understanding in the charter that the owners would look to their additional and extended insurances for the recovery of losses and expenses covered by those insurances.
Is implicit understanding a new term, a new phrase for implied term, or does it mean something different than that?
It's been referred to variously as an understanding on a true construction of the contract, or as an implied understanding. It's not been referred to expressly anywhere as an implied term as such.
I'm just wondering how you characterise it in normal contractual law, where we have express terms and implied terms, but we don't normally have something called an implicit understanding, which isn't one of those.
Well, the process of interpretation of contracts, one looks at the express words, one looks at the context, and one says what that actually means.
So that's your case, is it? This is what the express words mean.
That is the consequence of the express words, is that these parties have agreed to what has become loosely referred to as an insurance code,
right,
or in some of the cases an implicit understanding.
So you're not relying on an implied term. You're not saying this is so obvious as to go without saying, something like that. You're saying this is what the words mean, properly understood.
Correct. That's been the analysis of the House of Lords and the Supreme Court in the area and in the Ocean Victory. Both the Tribunal and Sir Nigel Terr answered the question in the affirmative. The Court of Appeal, whilst not deciding the issue, expressed some doubt but didn't explain its doubts. And in our submission, the Court of Appeal was wrong to do so. Submissions in summary for the moment, I'll expand the points shortly, but our submissions in summary are as follows. And for this purpose, it would be useful to have at hand the EVIA, which is page 670 and following. In the EVIA number 2, the House of Lords held...
This is your submission?
Yes, this is there are three aspects which I will then expand upon. The first is this. In the EVIA, the House of Lords held that the war risk clause in the Charter Party, which was clause 21 of the old Boldtime form, which both gave the ship owners an absolute veto upon employment that would bring the vessel within a zone made dangerous by identified war risks, and entitled the ship owners, should they choose nevertheless to proceed, to take out extra insurance specifically against such risk at charterer's expense, that amounted to a comprehensive insurance-based code under which the owners and their insurers were to bear all risks of unsafety arising from the dangers identified. Second submission, on a fair reading of the war risks regime in the EVIA number 2 Charter, all the elements of clause 21 that struck Lord Roskill as being of significance are also present in the war risks regime in the instant charter. If anything, we say the war risks regime in this case is rather more comprehensive and sophisticated than clause 21. Third, the reasoning of Lord Roskill in the EVIA number 2 applies equally to the present case. Let me now put flesh on the bones, beginning with the most pertinent authorities, and what I was proposing to do was to simply refer to the relevant passages in the authorities and then return to consider their application. The EVIA number 2, page 670, in this case, the appellant ship owners had time chartered the EVIA to the respondent charterers for a period of 18 months, 2 months more or less at charterer's option. The terms of the charter are at page 687, 688 and 689. It was the old bold-time form. Page 687 at clause 2, it contained a safe port warranty. The vessel to be employed in lawful trades for the carriage of lawful merchandise only between good and safe ports or places. And at page 688, it included a war risk clause, which, if I may invite your lordships and your ladyship to read, it begins 688H through to 689E. All of it is important for present purposes.
So, sorry, which clause?
Bottom of the page.
Bottom page 21, the rubric.
Yeah, I have it.
The war clause.
Yes, thank you.
Not at all. So we find both a safe port warranted clause 2 and a war clause at clause 21. The facts were that in March 1980, the charterers ordered the vessel to load a cargo for Basra on the west bank of the Shatt el Arab waterway, where she arrived on the 1st of July 1980. She was then trapped there following the outbreak of the Iran-Iraq war. The owners brought a claim in arbitration asserting that the charterers had been in breach of the safe port warranty and that the charter party had been frustrated. Charterers disputed the safe port claim and all argued that the war risks clause amounted to a comprehensive insurance-based code in respect of matters falling within its scope that trumped the safe port warranty in respect of such matters. The court case then made its way through the courts to the House of Lords. The House of Lords determined the case in charterers' favour for 2 reasons. First, the charterers had not breached the safe port warranty, so there was no breach of clause 2, they found. But secondly, as a separate self-standing basis, they held that the war risks regime in clause 21 was a complete insurance-based code under which owners and their insurers were to bear all risks of unsafety arising from the dangers referred to in that clause. And whilst the case is perhaps best known for the safe port analysis, it is important to note that the decision was based on 2 reasons. Neither of the 2 principal issues was given primacy in that introduction. So at page 690, B to 700A, Lord Roskill, in whose speech Lord Brandon had participated and with whose speech all the other members of the House agreed, he addressed the first of the two principal issues, the safe port issue, and he ruled against the owners on that issue. Then at page 700A, he turned to the second principal question, the code issue. At A, my lords, I now turn to consider the second main question. Does clause 21 operate as a complete code so that even if, apart from clause 21, there would be a breach by the time charterers of clause 2, clause 21, when read with clause 2, casts upon the owners and their insurers all risks of unsafety which arise from the dangers of the nature referred to in clause 21A, and thus frees the time charterers from liability for them.
Mr. Hoffman, I'm sorry, I'm going to have to interrupt you again. Like Lord Hamlin, I'm having serious problems retaining the documents on my screen. We'll have to adjourn for another 5 minutes. I'm so sorry. Thank you very much, Mr. Hoffman. I understand the IT people have put us on a new document reader because I was not alone in having my bundle crashing. As a result of the loss of time, subject to Council's convenience, I propose that we sit this afternoon till 4:30. So we just move the timetable by half an hour, which should recompense you for the time lost.
I'm most grateful to your Lordship. Thank you so much. It's certainly not inconvenient for me, and I'm sure, no, thank you so much. I'm most grateful for that. My Lords, my Lady, I was at page 700 in the speech of Lord Roskill written by him and Lord Brandon at page A to B. I had just read down to B. And Lord Roskill then made 4 observations about the charter clauses in that case. My Lords, 4 observations may be made at the outset. First, clause 21A gives the owners an unqualified right to refuse to accept orders for the ship to go or to continue to any place or on any voyage or to be used in any service which will subject her to any of the dangers to which this subclause refers. Secondly, under clause 21B, the owners can, in the circumstances there prescribed, insure the ship and charge the premiums to the time charterers. Thirdly, notwithstanding the off-hire clause, clause 11A, the ship is to stay on hire in the circumstances predicated in clause 21B2. Fourthly, whereas clause 2 bears the rubric trade, clause 21 bears the rubric war, and it is permissible to consider these rubrics when construing the various clauses. Lord Roskill went on to characterise the issue before the House at D, my Lords, whether clause 21 is a complete code and thus exhaustive of the owner's rights depends upon the construction of the time charter party as a whole, before immediately setting out what appears to have been the most influential point in his reasoning at D to F. But if the owners are right that clause 21 leaves the time charter's obligation under clause 2 in full force and effect, one remarkable result follows. The time charterers are to repay to the owners the premiums for the extra insurance, including extra war risk insurance premiums. But if the dangers against the risks on which they have paid those premiums materialise and cause loss or damage to the ship, then war risk insurers, upon payment of the relevant claim, become subrogated to the owner's rights against time charterers for the assumed breach of Clause 2. My Lord, this results would no doubt be highly attractive to war risk insurers, but the less fortunate time charterers would have paid the premiums not only for no benefit for themselves, but without shedding any of the liabilities which Clause 2 would, apart from Clause 21, impose upon them. Of course, the duplication of rights of recovery is not unknown. Indeed, it is because of such duplication that subrogation rights can be enforced. Lord Roskill then addressed and dismissed an argument premised on the Sussex Oak, which is of no bearing in this case, before resuming on page 701 at A. In the instant case, Clause 21 gives the owners an absolute veto upon employment, which will imperil the ship in the various circumstances for which Clause 21A provides. They can impose their own terms. Clause 21B also protects the owners in circumstances in which, as in the present, they have not been able to impose a veto because the dangers have arisen too late for the consent to be required and given or refused. His Lordship then concluded at B and D, on this matter, I respectfully and entirely agree with Lord Denning, the Master of the Rolls, and Sir Sebag Shaw, and equally respectfully disagree with Lord Justice Ackner and Mr. Justice Robert Goff. I should add that I regret that I am unable to follow the reasoning in the last sentence of paragraph 3 of the judgment of Lord Justice Ackner, which deals with this issue, where he says that in construing Clause 2, the insurance position must be ignored. This suggests that Clause 21 is to be construed in isolation from Clause 2, but Clause 2 and any other relevant clause must be construed together, and with all respect to the learned Lord Justice, it is not the conditions of any insurance policy which matter, but the fact that Clause 21 makes provision for the effecting of extra insurance, including war risk insurance, at the time charterer's expense, which is the relevant consideration. The second argument on which I reject the appellant's submission is that in any event, Clause 21 frees the respondents from any liability under which they might otherwise be. Now, I leave open at that page for the moment, but in due course, the court will find it worth considering what had been said by Lord Denning in the Court of Appeal, with which Lord Roskill entirely agreed. We've set that out in our written case, and I won't repeat it now. I will come back to it in a moment in the application of the case to the facts. It's also instructive to note what had been said by Mr. Justice Robert Goff in the Commercial Court and by Lord Justice Ackner in the Court of Appeal, which was expressly rejected by Lord Roskill. It is striking that Lord Roskill expressly rejected reasoning to the effect that Clause 21 merely involved a transaction by which charterers procured the vessel's entry into an excluded zone for the price of having to pay the owner's additional insurance premiums. That reasoning was expressly rejected. The next case which the court will have in mind, and I'll come to it in a moment, is the Ocean Victory. For present purposes, by way of introduction, the Supreme Court's relatively recent endorsement in the Ocean Victory of the approach in the Evier number 2 and the majority's express agreement with the remarks of Lord Justice Longmore, giving the judgment of the Court of Appeal, weigh heavily in support of the appellant's case, and in particular his statement about the natural expectations when one party is responsible for the premium of another party's insurance. Now, just for a note for the moment, Lord Justice Mayles, in his judgment, said at paragraph 41, page 144, it is questionable whether the majority of the Supreme Court went so far as to approve these passages from Lord Justice Longmore's judgment, in his judgment in the Ocean Victory. However, Lord Toulson stated expressly that he agreed with both the reasoning and the conclusion of the Court of Appeal. He does say at the end of his judgment that he agrees with the outcome, but it seems as if Lord Justice Mayles had forgotten that at the beginning of his judgment, Lord Toulson expressly stated that he agreed with both the reasoning and the conclusion of the Court of Appeal. And in our respectful submission, this is the first of the 5 errors in the reasoning of Lord Justice Mayles.
He doesn't specifically endorse that passage you rely upon Justice Longmore's judgment.
He doesn't specifically endorse any particular passage, no, but he endorses both the reasoning and the conclusion, and in our respectful submission, that is part of the reason.
What's the reference for the endorsement?
The endorsement is in the judgment, which is at page... I'm sorry. It's... It's page 663, page 664, top of 664, paragraph 128. Paragraph 128, top of page 664, at A to B, on the issue as to the effect of the Charter's joint insurance provisions, I agree with the reasoning and conclusion of the Court of Appeal, and disagree with Lord Clark and Lord Sumption for reasons explained in the rest of the judgment. And interestingly, well, I'll come back to that later, he does, at the end of his judgment, at paragraph 146, page 669, say, for those reasons I would have upheld the decision of the Court of Appeal on the recoverability issue if the demise charters had been in breach of the safe port warranty. And I suspect it's that which Lord Justice Mayles had in mind, and in our respectful submission had overlooked paragraph 128. Another case to which we referred in our written case, and again which I won't take you to now in the interest of saving time, is a recent decision in Palliser and Fate, decision of Andrew Burrows QC, as he then was. That's at page 737 for the record, and at page 744 he has a useful analysis of the position, and it's useful not least because it reveals in his first point that the issue of whether there exists an implied insurance code is not a formulaic test based on the EVIA. One must look, and I quote from his judgment, to see whether the contractual arrangements between the parties are such that the parties had agreed that compensation should be dealt with by insurance payments rather than the normal rules of tort and breach of contract. So there's no need for there to be an entirely comprehensive code. What matters in our submission is that the relevant clauses are sufficiently sophisticated, wide-ranging and potent so as to suggest that the parties did indeed mean to create an insurance-based solution that relieved the party that might otherwise have been liable to recover some or all of the other party's losses. And a particularly weighting factor will be the natural expectation that a party responsible for the insurance premium should not then be exposed to liability for losses covered by that insurance, because such claims would be precluded, nor should those on whose behalf he has paid the premium. The nature of the contractual arrangement is that compensation should be dealt with by insurance payments rather than the normal rules of tort and breach of contract. The wronged party must look to the insurance fund. It does not have a claim against the wrongdoer. There's one point made by the owners in their written case that I should pick up at this juncture whilst looking at the Evia number 2. In their written case, at paragraph 22, the owners suggest that the Evia number 2 forms the backbone of Cargo Interests case on issue 1. That is correct. However, in the next sentence, it is then said that it is said to support the argument that simply by reason of a charterer agreeing to pay for additional war risks premiums, an intention may be inferred between owner and charterer that an exclusive insurance solution exists for claims falling within the owner's war risks insurance. In our respectful submission, this is a misrepresentation of Cargo Interests' argument. At paragraph 18 of our written case, we say that we place significant reliance on it. We state expressly elsewhere that we rely on numerous features and not just that. And in our submission, the misrepresentation is also surprising because it's never been suggested by Cargo Interests that this fact alone is sufficient. The misrepresentation, which is repeated, infects the owner's further submissions. So, for example, when the owners come to answer the question, do the war risks clauses collectively amount to a code? This is page 105, paragraphs 45 to 46. The answer is, a short and sufficient point is that it is not enough, and it never has been. Well, we agree, but it is no answer to the case we make, which is based on a sophisticated arrangement. We do say that the agreement that the charterer should pay the owner's additional war risk premium is an important factor in support of an exclusive solution. In the Evia number 2, it was considered to be the most important factor, and also so in this case, but it is not sufficient on its own, and we have never suggested otherwise. If I can then turn to an application of the authorities in the present context, and again, if I can invite your Lordships and your Ladyship to return to page 700 in the speech of Lord Roskill, and we say much the same observations may be made of the war risks regime in the instant case as were made by Lord Roskill in the Evia number 2. If one looks at the 4 factors Lord Roskill identifies at B to C, the following points can be made. First factor, much like clause 21A in that case, clause 39 in our case provides the owners with sweeping rights and liberties to cancel or substantially vary performance of the charter and hence the bill of lading contracts if faced with war risks at any point during the various phases of the contractual voyage, albeit tailored to suit employment for a single voyage rather than for various voyages during the period of time, because this was a time charter. Now, this first point, the owners somewhat grudgingly accept that it is present. Second point, like clause 21B1, and those clauses are to be found at page 689, much like clause 28B1, the Gulf of Aden clause and the war risk clause make it clear that the owners can charge to their contractual counterparts the additional premiums for insuring the ship before exposing it to war risks in areas that would not otherwise be covered by their basic insurers. The owners again accept that this contextual element is present. Third factor on page 700, and this appears to be the battleground between the parties. The owners contend that this factor is absent. We suggest to the contrary. We say, much like clause 21b(2), clause 39 makes provision for the owners to be paid for the charter service even when they exercise their rights and liberties under the war risks regime. As the charter is a voyage charter, and the bill of lading contracts likewise cover a single laden voyage, that provision is necessarily more complicated than merely stipulating that hire shall continue to be paid. In the owner's words, a disapplication of the off-hire provisions. But nevertheless, we say, provision is made, for example, for freight to be paid, even when the contracted voyage originally planned is not contemplated, that's clause 39(3), or is completed in a different manner, for example, by a longer route than customary or expected, that's clause 39(4). It provides further for owners to be remunerated in respect of time lost and expense incurred in performing a different or truncated voyage, so that they contracted to perform absent the rights and liberties given them in clause 39. The most important feature is that the owners continue to be rewarded fully for the performance of the contract of carriage. In addition, under this third point, the Gulf of Aden clause and the additional war risks clause provide for an allocation of costs and responsibility for time and expense incurred by reason of trading through excluded areas that departs from the Charter's normal regime for such matters. For example, additional costs, time and bunkers used whilst the vessel transits the Gulf of Aden in accordance with the rights and liberties given to the owners are split 50-50, when the risk of incurring such costs, losing to such time, would normally be borne by the owners under a voyage charter. And then Lord Roskill's fourth point, 700C, just like clauses 2 and 21, the clauses making up the war risks regime bear the rubric of war risks and Gulf of Aden, in contrast to the routine clauses covering routine matters. And so we say the war risk regime in the instant charter, comprising clause 39, the Gulf of Aden clause and the additional war risks clause, creates a regime as sophisticated as that in the Evier number 2, if not more sophisticated. Further, using the language of the owners in their written case at paragraph 25, the war risks clauses, quote, created an additional onerous obligation on the charterers and imbued the owners with an extra benefit. So those are the four observations made by Lord Roskill.
And what would you say those additional, how would you describe the totality of those additional onerous obligations placed on the charterers?
The additional onerous obligations placed upon the charterers were that they were obliged to pick up insurance premium costs, other costs, bunker costs, additional remuneration for travelling much greater distances, they were obliged to pick up all of those costs.
Well, it might be helpful if you specifically identified the provisions you're relying upon in terms of additional obligations, aside from the premium.
Yes.
I mean, you do this at a later stage, but I think it would be helpful.
Perhaps, if I can perhaps come back to that, and I will identify in clause 39.
And also, although this comes later,
Yes.
as I understand it, you accept that not all of the all risk clauses would be incorporated into the bills of lading, correct?
Correct.
So it'd be helpful to know which parts do not get incorporated on your case.
Yes. Thank you so much. Then, if I may go to page 701, where Lord Roskell's actual reasoning is set out. At 701A to D, he identifies two relevant considerations. The first factor is the provision given to owners by clause 21 of an absolute veto upon employment, which will imperil the ship in the various circumstances for which the clause provides. They can impose their own terms, and much the same observations can be made by the war risks regime in the instant charter. Indeed, if clause 21 of the old bold-time form amounted to the requisite complete code of the House of Lords, the significantly more detailed and sophisticated war risks regime in this case must surely do so as well. Then the second factor is that clause 21 makes provision for the effecting of extra insurance, including war risks insurance at the time charterer's expense, and again applying the same analysis to the present case. The war risks regime freed the charterers from any liability to contribute to general average, under which they might otherwise have been pursuant to the normal contractual regime. The owners were to look for recompense in respect of their losses and liabilities, which were not general average, solely to the additional war risks cover and the kidnap and ransom cover, rather than to their contractual counterparties for whose accounts the premium for that additional cover were paid. And it's worth noting at C to D, Lord Roskell's clear statement as to what is the relevant consideration. It's not the conditions of any insurance policy which matter, but clause 21 makes provision for the effecting of extra insurance, including war risks insurance, at the time charterer's expense, which is the relevant consideration.
Charterers wouldn't normally contribute to general average, would they?
Charterers may contribute to general average, yes.
But not for the cargo.
Not for cargo, for freight.
So how does that work? How does the general average share get calculated? I thought general average works on the basis that all the property, the value of all the property was added up and divided between the people who own it. But
all the interests, both property and financial.
Right.
Correct. Yes. But the point I was seeking to make was a different one, which is that the claim under the insurance policy by the owners is not a claim for general average. The claim under the insurance policy by the owners is a claim for kidnap and ransom. That expense is what is said to give rise to a claim for general average. But the peril which gives rise to a loss is undoubtedly covered under owner's insurance, both its additional war risk insurance and its kidnap and ransom insurance. Those were the perils against which it insured, and was entitled to recover the full loss, the full ransom, under those provisions.
Can I just ask you about this point that you rely on, that Lord Roskill makes at the top of page 701, that the owners have an absolute veto on employment which will imperil the ship, and you were very clear when we were going through the clauses that clause 39 still applies, even though they've taken out this insurance to go through the Gulf of Aden. It's still up to the master to decide. So how does that, can you express what the significance of that is to this debate about whether the owner's insurance is therefore solely liable? Is it as simple as, well, it's your insurer, you could have decided not to go through the Gulf, therefore it's on you if you decide to go through the Gulf, and therefore on your insurers and not on us? Or is it a more sophisticated point than that?
I think the important point is that one analysis might be that you have paid the insurance premium to procure a carriage on a particular route. And the alternative is where you've paid an additional premium, but you haven't procured that right, the owners retain an absolute veto not to go on that route if for any reason they consider it unsafe to do so. And that is the fundamental distinction. On the one hand, you're purchasing the right to require the owners to go there. On the other hand, you're paying the additional premiums, which will give it the liberty to go there should it choose to do so.
But why does that affect whether the charterer should or should not be liable to contribute in the event that the risk eventuates?
Because as a consequence of the sophisticated insurance fund arrangement, the agreement, the contractual arrangement between the owner and the charterer is that in the event of these eventualities happening, a loss by a risk insured under these additional insurances occurring, then you will look to the insurance fund to make good that loss, and that will be the end of the matter. There will be no further claims surviving.
But you say our case is like the Avia because it wasn't that the charterers were paying a premium to procure a particular route. It was the second of your alternatives, that they were obtaining the insurance, which may, as I think my Lord Legate suggested earlier, may have encouraged the owner to take the risk of going through the Gulf, but didn't require them to do it.
If you go, the charter says, if you choose to go there, we'll pay the additional premiums, and the code imposed by Lord Roskill in the area says that it gives rise to, in all of these circumstances, to an agreement between the parties that if the matters insured against eventuate, they will look to the insurers to pay.
But the charterers also promise that if you decide not to go through the Gulf because it's just too dangerous, and you go the long way round, we will pay half of the additional costs of that voyage.
No, under clause 39(4, if the owner chooses to go round the Cape of Good Hope,
yes,
the charterer is obliged to pay all of the additional expenses, not just part of them. The 50/50 only applies if one goes through the Gulf of Aden.
Oh, and they have to have a protection, and they can only go through.
So is the reasoning along the lines, well, you can't explain this payment for the insurance on the basis that you're, in return for that, you're getting the right that they'll go into the dangerous area, which was sort of Lord Ackner's explanation for it. doesn't work because you're not getting that right. They can still choose not to go there anyway.
Correct.
So what is the point of purchasing this, paying for the insurance?
Correct.
Well, it must be to relieve you of some obligations you would otherwise potentially have.
Correct. Entirely so. And indeed, that was also the reasoning of Mr. Justice Robert Goff, as he then was, which was rejected expressly. And yes.
But it must be very rare for a charter party to oblige the ship owner to take the vessel into a dangerous zone if the master thinks it's not a good idea.
Entirely so, but there are cases. I mean, the Helen Miller is an example, a case in point, which is in the bundle. And so I went to the reasoning on page 701, and so we say we find present in the instant charter both of the factors on which Lord Roskill relied in reaching his conclusion. On a fair reading of the war risks regime in the instant charter, we say all the elements are present, and indeed I made the point that we say they're even more sophisticated. And Lord Roskill's remarkable result observation, D to F on page 700, applies equally in the instant charter. It would be an equally remarkable result for the charterers to be liable for the additional war risks and kidnap and ransom premiums, not only for no benefit for themselves, but without shedding any of the liabilities to contribute in general average to expenses and costs covered by the war risk and kidnap and ransom insurance, which the separate and generally applicable general average provisions would, apart from the war risks regime, impose upon them. Indeed, we say a fortiori, whereas here the liability would be one that involves no fault or breach of contract on the part of the charterers or the holders of the bills of lading. And illustrated in this way, had the Evier been struck by a missile during the voyage while transiting a danger zone covered by Clause 21, but while outside the geographical scope of the safe port warranty, there can be no real doubt that the House of Lords would have used the same reasoning to dismiss a claim by the owners for a contribution in general average in respect of the repair costs and the like. I've referred, and I'm not going to spend more time on the Court of Appeal, Lord Denning's decision at the moment, but perhaps just to pick up the rejected reasoning very quickly. In the again, I'm not going to waste time if I take you to the authority now. It's in our written case. I will just make the submission. But the rejected reasoning is revealing. The remarks of Mr. Justice Robert Goff are of interest because they involve an express statement that Clause 21 was, quote, merely dealing with the cost of insurance and delay in the face of war risks, rather than providing a comprehensive code for dealing with costs incurred and losses suffered in face of such war risks. And that reasoning was expressly rejected by the House of Lords. As regards Lord Ackner, it's striking that Lord Roskill expressly rejected the reasoning to the effect that Clause 21 again merely involved a transaction by which the charterers procured the vessel's entry into an excluded zone for the price of having to pay the owners additional premiums. In the view of the House of Lords and the majority in the Court of Appeal, the clause had a far more far-reaching effect. Then, as regards the Ocean Victory, that's page 621. Here we don't contend that there is any direct analogy between the sets of clauses in the Ocean Victory on the one hand and the Evier and the present case on the other hand. It's the reasoning of the majority upon which we rely, and in particular what Lord Toulson says at pages 666 to 669. And in essence, he picks up and approves the reasoning of the Court of Appeal.
Which paragraph?
Sorry, just bear for a moment. He poses the question at 139. He deals with the House of Lords case in the Cooperative Retail Services and Taylor Young Partnership, and at paragraph 140F to G, he says the House of Lords, upholding a decision of the first instance judge and the Court of Appeal, held that it cannot have been the parties' intention that parties who were jointly insured under a contractors' all risks policy could make claims against. So he deals with the joint insurance position in that paragraph. And at 141, he says, in the present case, the Court of Appeal followed that reasoning, that the proper construction of clause 12, which was the relevant clause in that charter, was that there was to be an insurance-funded result in the event of loss or damage to the vessel by marine risks, and that if the demise charters had been in breach of the safeport clause, they would have been under no liability to the owners for the amount of the insured loss, because they had made provision for looking to the insurance proceeds for the compensation. It did not consider that the introduction of clause 29 was intended to alter the way in which clause 12 was to operate, and then says, I agree with the Court of Appeal. I noticed the time, my Lords, I was going to go next to the Court of Appeal and look at the relevant paragraph in Lord Justice Longmore's judgment. Would that be a convenient moment, or shall I finish this section?
How long do you think you would take to finish this section?
I won't be long at all. I'll be less than 5 minutes.
Continue then.
Thank you so much. I can take it quickly because I can take it from the judgment of the Supreme Court, page 664. I've taken you to A to B, where he agrees with the Court of Appeal's reasoning. No, I think I'm going to need to take you. It's page 995.
What do we take from page 664?
I was repeating myself, and I apologise for that. It's merely reference to the adoption of the reasoning and conclusions.
Yes, I see. And so we're now going to
995.
We're now going to show us part of the reasoning you say was endorsed.
Correct.
This is the judgment of, yes, Lord Justice.
This is the judgment of Lord Justice Longmore, but it was a judgment to which all of the members of the Constitution contributed. That's page 972. And he picks up this discussion at 995, paragraph 74, and we were not shown the terms of the actual insurance contract made between the demise charterers and the insurers, but we were invited to assume that a contract had been made in joint names in conformity with clause 12. Such contracts have been given rise to problems in relation to subrogation for a number of years. Similar problems can also arise in the absence of joint insurance if one party to a commercial relationship is required to pay premiums for an insurance against loss or damage to the property insured. If a loss occurs as a result of a breach of contract or negligent conduct on the part of the party who pays the premium, can the insurer use the name of the innocent party to sue the guilty party once the insurer has paid for the loss? Since insurance is usually intended to cover insured for any breach of contract or duty on his part, it is generally thought that the answer to this question must be no, otherwise the party paying the premium has not secured the insurance cover he was entitled to expect, and then refers to the Evia number 2 and quotes over the page from the Evia number 2. And we say this paragraph provides powerful support for cargo interests argument in this case and reflects much the same point made in the Evia by both Lord Roskill and Lord Denning, the Master of the Rolls. Lord Justice Longwell stated that in respect of both cases of joint insurance and cases where one party to a commercial relationship is required to pay premiums for an insurance against loss or damage to the property insured, if a loss occurs as a result of a breach of contract or negligent conduct on the part of the party who pays the premium, the insurance is usually intended to cover him for any breach of contract or duty on his part.
So Ocean Victory was a joint insurance case, wasn't it?
It was a joint insurance.
This is obiter, what he said.
This is obiter. I should have said, and I apologise, my lord, this whole section of the judgment is obiter because of their decision on the safe port.
Right, but this point is double obiter.
It's double obiter, yes. If that's,
But you accept, I think, that he maybe goes a little far if he, because I think you said at the outset that you're not saying that the mere fact of the charterer paying the premium is enough to create the code. So you don't rely on it to this extent, to that extent.
Well, we would say that Lord Justice Longmore was only addressing it as a factor, right, rather than setting out what other matters needed to be in play in order for there to be a sophisticated insurance code. And then having referred to the Evia number 2 at page 996 and the Mark Rowlands case, paragraph 76, and it's interesting, the Mark Rowlands case is another example of an insurance code where there is no joint insurance, and he relies on that, and at 997 he concludes two-thirds of the way down on the left-hand column before paragraph 78. Thus, even in a case where there was no provision for joint insurance, but the insurance was paid for by the guilty party, the insurance was held to cover the liability of that party, and no rights of subrogation existed. And then these words are very important. Clear words to exclude that possibility were not required once it was evident that the insurance was intended to be for the joint benefit of the parties. And the second error in Lord Justice Males's judgment in our respectful submission was to suggest the contrary at paragraph 57 of his judgment. That is a matter that I will come to later. So we submit that the Supreme Court's recent endorsement of the approach in the Evia and the majority's express agreement with the reasoning and conclusions of the Court of Appeal weigh heavily in support of owner's case. I've now finished that particular topic, and if that is a convenient moment.
That would be a convenient place for us to pause.
Thank you so much.
The court will now adjourn. Thank you very much.